Hey, Sean and Raj here with Unblinded, seeing we don't see about the fun and
guys.
excitement of exponentially growing your sales and practice. So Raj, congratulations,
Thank
brother.
you so much, Sean.
We have some
Thank you.
huge news. What happened?
The 6-year statute of limitations for medical providers and for workers' compensation claims was affirmed by the Supreme Court of New Jersey. They affirmed the appellate decision. We represented the
So we're gonna help Raj convey his unique identity better. So this is always coaching and training. So here's what happened, right? Is this what happened?
Go ahead.
So there's a huge issue affecting tens of millions, if not hundreds of millions of dollars in workers' comp claims not paid to medical providers and hospitals in the state of New Jersey. Is that a fair issue?
That's fair assessment, yeah.
Yeah, okay. And so the question was, is it a 2-year or a 6-year statute of limitations? And we have pioneered this issue at Callagy Law.
Yes.
Raj, Tom, Michael, team.
Michael,
Fair?
yeah, absolutely.
Okay, but who wrote the papers?
I wrote the papers.
Raj wrote the papers. So fantastic job.
Thank you so
And
much.
how many cases were at play just related to our firm, would you say, that were impacted by this question?
I would say it would be in the hundreds.
Yeah, hundreds of cases and tens of thousands of cases potentially in the state of New Jersey.
Oh,
Fair?
absolutely.
Okay,
Yeah.
amazing. That are not even filed yet.
Yeah.
So
and future cases, because it's brought in, it's 6 now, and they were saying it's
and future
6.
cases.
Yeah.
So there was a lower court level, and at the trial level,
Right.
did we win or lose in this issue?
Well, we weren't part of the trial level.
Okay.
We served as...
So at the trial level, the decision was.
Oh,
what?
the decision was we lost. Yes, the medical provider. It was
The medical
against
provider,
the
not
medical
us,
provider.
but other people
Yes.
lost. So then it went up to the appellate division. So this is an issue at the trial level. They said, no, it's 2 years.
Right.
And they went with the insurance company.
Yeah.
And then at the appellate level, right, victory, correct? For the
Victory,
6-year
absolutely.
overturn.
Yeah.
At the so now we're at the New Jersey Supreme Court.
Right.
The highest court in the state of New Jersey. That's what's present and what's going on. And so you write the papers.
I do, yes.
Right? And Michael Smikin makes the oral argument.
Absolutely.
Which we will actually put back up again with this video, because Michael did a phenomenal
Exceptional job.
And what happens?
All 6 of the judges on the bench
Right, there's 6 judges, right? And all 6.
rule in our favor that there is a 6-year statute of limitations for the medical provider in the state of New Jersey.
Yeah, that is a fantastic job. Very exciting day for medical providers in the state of New Jersey. Incredibly exciting day here at Callagy Law. Contain your enthusiasm, everybody. So, yeah, right, no, amazing job. And thank you to everybody who worked on this, because so many people
Absolutely.
throughout the workers' comp team, the TAs, everybody across the board has been a part of this. How long has this issue been brewing?
Well, it's been brewing
That we've been dealing with, at least.
since 2012, since the amendment took place in workers' comp.
8 years. 8 years, and we have a New Jersey Supreme Court victory.
Yes.
That's a beautiful thing. Thank you for that. It's an amazing thing that you accomplished. It's amazing to have accomplished it on behalf of the firm. Much more importantly, on behalf of medical providers and patients, because this affects how patients are
Yes.
cared for and how people want to see them and all
Absolutely.
of these great things. And it leads to other issues that are now going to be settled and resolved, I think, finally, favorably as well. Yes?
Absolutely, yeah,
Right.
and we're very much part of those issues that are also coming.
Yes. So, Raj, you know what? And folks out there, even the trial courts sometimes are blind. And Raj, they're just learning to see. Thanks.
On behalf of the Medical Society of New Jersey, I join my colleague. Medical providers are not claimants, and they never have been. So we've been doing this for 12 years now, and the employee has a claim petition, and at first, medical providers used to file claim petitions, but then they were specifically instructed that you are not claimants, you are medical providers. And a new application was created solely for the medical provider to file their claims, referred to as a medical provider's application for medical reimbursement for medical treatment, a super redundantly named document, but it exists, and that's what medical providers use to file their claims. They've never been treated as claimants, and they've never been treated as anything other than medical providers who are looking for reimbursement for services that are provided. What is so interesting is that there's this whole discussion about how we're creating new law, and it's never been 6 years, and it's always been 2 years, and the respondents are saying that no, it's always been 6 years. Well, guess what? There's a case remarkably prescient in 1948 called Oldfield by this court, the Supreme Court. And what the Supreme Court was addressing in Oldfields was a claimant saying that it is the medical provider's receipt of payment that tolls the statute of limitations. And the Supreme Court says the employer has a statutory duty That statutory duty is to provide medical treatment. Once they've provided the treatment, the obligation between the employer and the employee is at an end. The case law specifically says then, how or when he shall pay for the same is of no concern to the workman. The very next sentence, the Supreme Court then says that the employer can be sued by the physician, and the statute of limitations, 6 years.
Here's our PS to the video. And I'll just say this, but don't tell anybody. There were people that represented medical providers that were actually arguing against this that would have helped the insurance company. And they did it for the second time. And they represent lots of medical providers. It's crazy. And I think we have to go educate people on who they are and what's going on. But we'll see what happens next.
We'll see what happens.